Officer Day, would you open the courtroom for us, please?
State of Michigan's 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Morning, Your Honor.
Morning, counsel. Waiting for Mr. Tantello to come in here.
Sounds good.
Connecting him up to audio now, hopefully. This isn't working. Let's try putting it back in the waiting room. See if we can't do a little bit better this time. I don't have audio from him yet, but at least I have video.
Sorry.
All right, let's get started on this file. This is file number 23-142754, CET Pharmacy Service versus City of Detroit. Could I have your respective appearances?
James Santolo on behalf of CET Pharmacy.
You a member of the State Bar of Michigan?
Sorry, Judge?
Are you a member of the State Bar of Michigan?
Yes, sir, I am.
You probably have a P number.
I do, sir.
Is it classified or is it available for general knowledge?
I beg your pardon, Judge. P number is 85401.
Counsel, your appearance.
Good morning, Your Honor. Christopher Michaels, P83156 on behalf of the City of Detroit.
All right, gentlemen, this is our second pretrial on this case. Plaintiff's counsel, what's your claim amount now?
Claim amount is a little bit more than $11,000. I've got $11,455 on file.
So you're not going to get over my max, doesn't seem like. So we've done our 2.302A disclosures. Where are we on this file?
Yes.
Your Honor, if I may, this is a companion case. I think I have a couple other cases in front of you. There was a fraudulently staged bus accident, which I think it's 5 different claimants have all made claims, and we're still trying to do investigation into who knew what happened and when did they know it. So since it is I at this point have no information as to whether or not CET Pharmacy was involved, but I would like some discovery to see just the basic levels of if they could be. They could have some connection.
In your other cases, aren't you?
In one other case, I believe it's a different claimant, same pharmacy, and we are doing discovery. So yeah.
Why would I duplicate that and make the case more complicated?
Your Honor, it's fine that I'm doing it in the other case. I just wanted to apprise the court of where we are on this file, that we're still doing investigation. So
our next date will be July 27 at 10 a.m. And there doesn't seem to be anything else we can get done today. So let's get you on your way and let you go to work and do other things. Anything else, gentlemen?
No, sir.
Let's be safe. July 27, 10 a.m. Thank you for coming in.
Thank you, Your Honor.
All right,
Good morning, Your Honor.
good morning. Let's get her to unmute. All right, we seem to have both sides. Let's get started. We are on the record calling case number 22-243-350. Alyssa Botchway, versus Livernois Oral Express. Could I have your appearances?
Elisa Botchway.
Good morning, Your Honor. Michael Holmes, P46095 on behalf of the defendant.
Okay, taking a look at the file, it appears that on June 1st, the court entered an order compelling discovery and other relief. And that order provided that on or before June 15th, the plaintiff was to respond and answer to interrogatories and requests for production of documents which had been served back in January. Was that done,
No, Your Honor.
ma'am?
Your Honor, I have been trying to find the car. Every time I called the place where Mr. Mike told me the car was at, they said they didn't have my car. I just recently found the car 2 days ago, and I called Mr. Beal to come pick the car up. He didn't let me come. He haven't been answering his phone. I just had death in the family. So
You didn't comply with the court's order. That's the bottom line here. All right, this is what we're going to do. I'm going to enter an order. Mr. Holmes, you're going to draft it. The order will provide that the plaintiff failed to comply with the order dated June 1st, 2001 in regard to the interrogatories and requests for production of documents that were served on January 16th, 2013. She will have until July 25th to make full and complete responses to those interrogatories and requests for production of documents. If she does not do so, this case will be dismissed with prejudice. Ma'am, you are the plaintiff. You have to provide information concerning the claim you made. We will see you all July 27th at 10 a.m. Counsel, I look forward to your order under the 7-day rule. You understand what I've said here, ma'am?
yes, sir.
July 27th is our next date at 10 o'clock, and you will have until July 25th to file and serve those discovery requests that the court had ordered you to do by June 15th. We'll see you then, July 27th. July 27th. Mr. Holmes, I look forward to your order under the 7-day rule.
Your Honor, can I submit that to the court via fax like before? Because when I,
Right, sir.
is that okay?
That's gonna be fine.
Okay, thank you, Judge. Thank you very much. Have a good
Thank you
day.
both for coming in. Let's be safe.
You too. Thank you. Have a good holiday.
You too, sir. Hello?
Hi, good morning.
What can I do for you?
I thought I had an appointment. Is it 10 o'clock or 11 o'clock? It's Mary Polly.
You're 11 o'clock, ma'am. You're a little bit early.
I'm a little early. All right, I'll see you.
I'll see you at 11 then. Thank you.
Bye.
Hello?
Hello,
What is your name?
Marvin Hunter.
Hold on, we'll get started.
Delineate between how a student views themselves and their identity. What can now be considered?
We are on the record. This is file number 23-240-200. Marvin Hunter
Correct.
versus LIJBS Towing. Your appearances.
Yeah,
Tell me your name, sir.
Marvin Hunter.
Counsel, your appearance.
Your Honor, I'm Frank Rhodes, P 24119, appearing on behalf of the defendant LIJBS Towing.
All right. I want to go over a couple of things here. First of all, Mr. Hunter, you're the plaintiff in this case. You started this case in the small claims division. As is the right of the defendant, the matter was removed to general civil. I want you to understand how much different general civil is than small claims. In small claims, the rules of evidence other than privilege do not apply, and the court is not required to follow the Michigan court rules or statutory or case law, but is instead to do, quote, substantial justice. That is not where we are now. We are now in the general civil division, which is much more formal. In the general civil division, the rules of evidence do apply. In the general civil division, all parties, plaintiff and defendant, are required to follow the Michigan court rules as well as case law and statutes. You understand what I've said to you?
Case law, yes.
All right. Now, do you want to represent yourself or are you going to hire an attorney?
That was the whole thing. I've been trying to get an attorney to address general civil, but it's hard to find an attorney that does general civil.
Well,
I don't, and plus, I'm a small guy. This whole thing has inconvenienced me of work because my vehicle is my livelihood. I actually live on it, and it's still in the shop. So
Well,
I
sir,
haven't been able to work and make
sir,
any
this
money.
This is the claim you brought. You can't say that you're inconvenienced by the claim you brought. So here's what
I'm suing. I'm suing.
Okay, fine. If you don't have an attorney, you can represent yourself. You have an absolute constitutional right to do that. But what you do not have a right to your own set of rules of civil procedure. You do not have a right to your own rules and statutes. If you elect to represent yourself, as is your constitutional right, the same rules that are binding on the attorney are binding on you. You understand that?
Yeah, yes, I've been trying to find an attorney, and I don't have the money to afford one. Every attorney that I talk to, they want like $5,000 retainers, $7,000. I'm David in this situation. I'm dealing with a Goliath.
All right, we're going to move forward here. I opened your written discovery on June 1st after Mr. Rhodes filed his answer. What has been done by way of written discovery?
Your Honor, we sent on June 5th a request for production of documents to Mr. Hunter. And so under the court rules, he was not until, 4th of July to comply.
That's a holiday. Okay. All right, then this is what I'm going to do, gentlemen. I'm going to continue your pretrial for another 30 days. Your next day with me will be July 27, at 10 o'clock. Your written discovery will remain open. Is there anything else we can accomplish today?
No, Your Honor.
Oh,
Anything?
yeah. My question is, I had also put in a default of judgment because they hadn't responded at that time. I'm like, I don't, like I said, I don't understand that point anyway. When, okay, if they're not, if they didn't respond and I already had a default judgment, why did they get another chance to, damage my vehicle and inconvenience me of a livelihood? This is, I live off this. I'm homeless. I'm homeless because of this. It's a motor home. That's what I live on. That's what I live in. It's my residence. The union calls me to do certain jobs, to travel and go out of state. So I haven't been able to do any work because the motorhome is still in the shop.
The reason the default was not entered, although you filed it, is that counsel's appearance was filed on the same day. That's why I didn't enter the default. We'll see you guys again, July 27th at 10 o'clock. Your written discovery remains open. Thank you all for coming in. We are off the record.
Be safe, Your Honor.
July 27th at 10 o'clock. Yes, sir.
Thank you.
Good morning.
Good morning, Judge. How are you today?
I'm doing well. And yourself?
Doing okay.
You have Allied Bank versus Unique Frierson?
I do.
Okay. We don't have her as of yet, so we'll give her a few more minutes. I'll put you back in the waiting room.
Okay, sounds good.
Thank you.
You just heard Janina Fielkowski play the waltz in A-flat major, like a bone device by Friedrich Schiller. Here's a fun fact about this great romantic composer. Georges Sand was a female writer during the Romantic period and Chopin's lover. She gave him all sorts of nicknames like Monsieur Velvet Fingers, My Little Grasshopper, and Chop Chop. I love to imagine Chopin sitting at the piano practicing his scales and turning his head to the other room when he hears himself beckoned as Monsieur Velvet Fingers. I'm Florence Kay, filling in for June Nesrella on Tempo. This is CBC Music. Jennifer Higdon is one of America's most acclaimed and most frequently performed living composers. She received the Pulitzer Prize and 3 Grammys. Well, that says a lot. Prizes can mean a lot, but what means the most is that her music is heartfelt. Her composition Blue Cathedral is dedicated to the memory of her young friend, Andrew Blue. It's one of her most acclaimed works, and here it is by the Atlanta Symphony Orchestra, conducted by Robert Spanner.
Hello? 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 We are on the record calling file number 231448882, Allied Bank versus Unique Frierson. By a notice dated June 8th, 2023, and sent to the parties on that date. This matter is scheduled for hearing today at 10 o'clock on plaintiff's amended motion for summary disposition. It's now after 10:30. Could I have your appearance?
Good morning, Your Honor. Attorney Ashley, known as P77029 on behalf of plaintiff.
Ms. Notice, Ms. Frierson has failed to appear. Did she file any pleadings in response to either your motion for summary disposition or your amended motion for summary disposition?
She has not, and I believe the last time she did appear in court, which was not the last hearing, but the one before that, she did acknowledge that she received it and did not file an answer at that time.
I recall that. Well, in any event, why don't you proceed briefly with your motion for summary disposition?
Sure. So the defendant entered into a contract for the purchase of a vehicle with plaintiff. Defendant defaulted on that contract by failing to make payments as required. As a result, there was a deficiency balance in the amount of $11,734.93. Plaintiff is only seeking damages in the amount of $9,662.62. I had also sent discovery to the defendant, which she failed to answer, so everything is deemed admitted at that point. Her answer also served as an admission as she checked I don't know for all the boxes. She admitted on the record about the debt. She admitted about the contract as well as the default. She did not present any legally valid defense. She presents no genuine issue. And based on the pleadings alone, I would ask that our motion be granted today.
All right. Michigan Court Rule 2.312 provides for a discovery mechanism known as a request for admissions. And in this case, requests for admissions were served and were not answered. The rule is self-executing. Failure to answer a request for admission is deemed to be a conclusive admission of that fact, of the fact set in forth. And in the admissions, she admitted all of the things you're claiming. In any event, Under MCR 2.116G4, once a motion under C10 has been filed, a party may not rely upon their pleadings, but must, by affidavit or otherwise, show that there's a genuine issue of material fact. Here, she's filed no pleadings. Your unopposed motion for summary disposition under MCR 2.116C10 is therefore granted. I look forward to your order of judgment.
Thank you, Your Honor. I did attach a judgment to my brief.
You want to
It is-
use that one?
Yeah, it's page 10, I believe. On the amended motion.
Oh, on the amended motion, let's see.
Yeah, I think the original one I submitted, there was a number flub.
Yeah, that was the reason you meant. You want,
Yeah.
then I'll go ahead, I'll admit that one. All
Thank
right.
you, Your Honor.
Thank you, appreciate you coming in.
Have a great
Okay.
holiday.
And you too, bye-bye. You guys go, wait, I'm not spending any more time on board either.
The Atlanta Symphony Orchestra with director Robert Spann played Jennifer Hayden's Blue Cathedral, which she dedicated to the memory of her young brother. She says that the process of composing this piece was the most cathartic thing she's ever done. You're listening to Tempo on CBC Music, Live Landscape. In the movie Amadeus, Salieri says that he had never heard music quite like Mozart's. Stricken by jealousy, he said that this was no composition by a performing monkey, It seems to me that I was hearing the voice of God. But why? Why would God choose an obscene child to be his instrument? It was not to be believed. This piece had to be an accident. It had to be, it better be. Well, Salieri, I'm sorry to say, but it was no accident. Because Mozart's genius proved to be incomparable over and over again. This is this divine simple number 35, Catherine, played by the Salzburg Mozarteum Orchestra under the direction of Hans Kahn. That was the Salzburg Mozarteum Orchestra playing the marvelous Symphony Number 35 by Mozart, known as the Hafner Symphony. I'm Florence Gay, filling in for Julie Nesrella on Tempo, and this is CBC Music. Coming up after your news, more Tempo with Jean Bizet.
News, it's the world without. I'm Joe Cummings. The U.S. Supreme Court has struck down affirmative action involving college admissions. Chief Justice John Roberts says it's wrong for universities to consider color of skin over a student's talent or skills. Andy Brown Jackson, for a black female justice, is calling the conservative majority ruling a tragedy. In recent years, lower courts across the U.S. have consistently ruled that affirmative action does not discriminate against Asian American athletes.
Morning, counsel.
Good morning, Your Honor.
Let's see if I can get your other side here.
I'm here on two this morning too, Your Honor.
Okay, which other one do you have?
I'm not for sure which one you have in front of you.
Okay,
This
I've
is
got
Mr.
Vance
Vance
Hurt.
Hurt.
Yeah, I got Vance Hurt in front of me.
Okay, and I also here on the absolute resolution.
Got it.
Hassan.
He's
Okay,
here. He's here also.
okay, perfect.
All right, let's get started. I have Mr. Hurt here.
Good morning, Mr. Judge Robinson.
We are on the record calling file number 23145-788. The file is entitled LVNV Funding versus Vance Hurt. This is our, I guess, first and a half pretrial. We had an earlier pretrial where Mr. Hurt was unable to get audio working. But today we apparently have both audio and video. Your respective appearances, gentlemen.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff LVNV Funding.
Good morning, Your Honor. Vance Matthew Hurt.
Mr. Hurt, is it your intention to represent yourself in this matter?
Yes, Your Honor.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, your own statutes. if you elect to represent yourself, as is your constitutional right, the same rules that are binding on council are binding on you. You understand that?
I understand, Your Honor.
All right, gentlemen, the last time we were almost here, I opened your written discovery. What's been done, if anything, on that?
Your Honor, I just wanted to touch base with Mr. Hurt. Are you still working with Beyond Finance? We did receive a power of attorney from them regarding them representing you in terms of trying to settle this account. Is that accurate yet?
Sir, I do believe that this account was put into a restructure.
You're right.
And I was wondering why it went into where it's at now. And I was hoping that.
Other than receiving their power of attorney from them saying they're representing you on this account, we have not had any other contact with them in terms of any type of settlement negotiations. So I always advise people, touch base with them, let them know where we are in the lawsuit and that we're in the discovery period. And just, you know, sometimes it depends on the number of accounts you have that they're handling for you in terms of how much you have in your pool of funds to see if they can, you know, try to reach out to us to settle this. So just keep the hammer on them and hopefully we can get this one resolved.
I appreciate that, sir. In fact, I will get in contact with them today as soon as we're done.
Perfect.
All right, gentlemen, I'm going to continue our written discovery. Your next date with me will be July 27 at 11 o'clock. Does that work for everybody?
Yes, Your Honor.
Okay, I'll send out an order. Thank you both for coming in, and let's be safe out here.
Thank you, gentlemen.
Thank you, Your Honor.
Have a good day, sir. All right, I don't want to report him. You've got one more?
I have that absolute resolution. Yeah, that's the one.
All right, let's get him in here. All right. Can you hear me, sir? I don't hear you. Going, we seem to have a problem with the defendant and sound. I have video, but he doesn't have sound.
I wish I could say this is the first, but I know you run into this quite often.
I even have placards for
you know you run into the issue if you already make placards. So
There he is.
Yeah.
You got to learn how to use your equipment, counsel, sir. We are on the record. This is file number 23-141-546. Absolute Resolutions versus Hassan Salhoud. This is our second pretrial on this file. Your appearances.
Good morning, Your Honor. Once again, Brian Gruen, GROEN, P number 56673 on behalf of the plaintiff.
And what is your name, sir? Hello?
Yes, I am Hassan Shalhout.
All right, gentlemen, court opened your written discovery on June 29th. I'm sorry, June 1st, when we were last here. What has been done in that regard?
Your Honor, we're still, Mr. Hassan reached out to our office a few months ago and looks like he's kind of on fixed income. And this is, as the court is aware, a rather large balance owed on this card. So as of right now, nothing has been worked out.
Okay, then I will give you just another date. There's nothing else I can do at this point. Your next day with me will be July 27th at 11 o'clock. Your written discovery will continue. Is there anything else we can do today, gentlemen?
Not for today, Your Honor.
Anything for you, sir?
Yes, I want to tell you, sir, the resolution, what is called absolute resolution, they bought my debt after 6 years and 8 months. And my credit report, it's approved that. It's after the statute of limitations. And I never worked with this company or I have any agreement with them. And I have the proof from my credit report to prove the stats of limitation of my credit report.
Mr. Hassan, I can send you number one, the chain of title, which should have been part of the complaint, but I can send it out to you again. And I'll also send you some statements. We have your last payment was at the end of 2017. So that would be well within the 6-year statute of limitations from the date that you last paid on this account. So it is well within statute.
But my credit report proved that you bought my credit in November 22. After the statute limitation is 6 years and 2 months.
All right, let's stop right here. Sir,
yeah.
You going to represent yourself or you going to get a lawyer?
I want to represent, I can't afford a lawyer.
Then sir, you should, if you believe the statute of limitations has expired, you have a right to file a motion for summary disposition claiming that the statute of limitations has expired. You serve it on the court, you serve it on your opponent's counsel, you pay the motion fee, he has an opportunity to respond, and I will make a ruling. But we're not just going to have sidebars where you decide that this is what happens and this is what the law is. That's not the way it works.
Okay, you
want to file a motion for summary disposition based on your claim that the statute of limitation has expired, sir, I would urge you to do so. I will see you gentlemen again, July 27th at 11 o'clock. Your written discovery will remain open. Is there anything else to accomplish today?
I think we're set.
July 27 at 11 o'clock?
Yes, sir.
Okay, you want me to send a motion prove my stats limitation?
It is your claim, sir.
Yes.
It is your obligation to bring the motion before the court to say that and show that the statute of limitations has been expired here.
Okay.
You have to file a motion with the court. You serve a copy of the motion on the other side. You file a proof of service that is that you serve the other side. And the court will give him an opportunity to file a response. He has to send you a copy of his response, file a response with the court, and I'll set it for hearing, and I'll make a decision. But the court makes decisions of law, not litigants. That's why I get to wear the black robe. July 27th, gentlemen, 11 o'clock, written discovery remains open. Thank you.
Thank you.
Look forward to your motion, sir. Good morning.
Good morning.
I do not have your opponent as of yet. I'll get back to you shortly.
Okay.
So I'll put you back in the waiting room. I just want to let you know I knew you were here.
All right. Okay.
Over being tender. Yeah, come on.
The Malmo Symphony Orchestra with Maestro James DePriest played the Carmen Suite No. 1 by Diesel. I'm Florence Katie. This is Temple on CBC Music. Some of history's great music has been written almost like it was a soundtrack, based on images or stories. Think about The Carnival of the Animals by Saint-Saëns or Pictures at an Exhibition by Mussorgsky. He actually wrote it as a memorial to his friend, visual artist Victor Hartmann. Shortly after his death, Mussorgsky attended a retrospective exhibit of his friend's work, where he immediately felt the need to capture the essence of it in music. He wrote Pictures at an Exhibition as a 10-piece suite for piano based on 10 paintings by Hartmann. Those pieces are linked together by a recurring theme, which represents the visitor walking through the art gallery. Decades after Mussorgsky's death, Maurice Ravel adapted the suite for full symphony orchestra, which is how we most often hear this piece. Ravel uses all of the orchestral colors imaginable to bring these paintings to life. Here it is, played by the Toronto Symphony Orchestra, directed by Peter Ulgen.
We all messed up.
We are on the record calling file number 23146-290 Midland Credit Management versus Mary Polly. By notice dated June 1st, 2023, given to the parties at our last pretrial. This matter was set for pretrial today, June 29th, 2023 at 11 o'clock, a date and time agreed to by all parties. It's now after 11:30. Could I have your appearance?
Mary Polly.
The plaintiff has failed to appear. No good cause of that failure having been shown. Case is dismissed without prejudice. We'll send you out an order today, ma'am. Thank you for your patience.
Thank you.